Next, we will go to CB 80, council members Oriata and Blagay, Vacant Property Registry Program. For the purpose of establishing a vacant property registry program applying to unmaintained vacant residential, commercial, and industrial dwellings and buildings located in the county, providing for definitions, providing for the applicability of the provisions of this division, providing for the designation of unmaintained vacant dwellings and buildings, providing for certain inspections, providing for certain fines, certain exemptions, right to appeal, annual report, and generally regarding vacant dwellings and buildings. Ms. Zavagos?
Yes, thank you, Madam Chair. CB 80, 2023 amends the housing and property article. So we are further traveling on in this subtitle of the county code. The bill, as styled in draft 1, creates a vacant property registry, and that would apply to the unmaintained vacant residential, commercial, and industrial buildings and dwellings here in the county. It also provides for enforcement and inspection requirements and duties to be carried out by the Department of Permitting, Inspections, and Enforcement, and provides fines and certain exemptions. At the request of the bill's sponsor, a proposed draft 2 has been prepared, and hold on one second, let me see what I'm doing here. Okay, wait a minute, let me just see what we have. Okay, let me keep going. So the main provision of the bill is the designation and inspection of these unmaintained vacant buildings and dwellings. And the Director of Permitting, Inspections, and Enforcement would be required to notify the owner in writing that their building or dwelling has been designated, and they have the right to seek reconsideration and appeal. The annual inspections of unmaintained vacant dwellings are required, and they're only a vacant dwelling or building if the director, meaning of DPI, determines that there's no resident or owner for which it has an intent to return and occupy it, can be shown. They don't apply to government. The new provisions will not apply to government entities, certain real property under active construction or reno, certain properties that are under probate or are the subject of litigation, or if they're maintained otherwise in compliance with the code. The fine is $1,000 for a violation, and the director has a discretionary exemption from the inspection requirement for multifamily that has 50% of its units occupied. So the amendments in proposed draft 2. Should I go on and just do those since we have that out before us? Would that be acceptable to the bill sponsor? Okay. So amendment number 1, and it basically provides that the director may grant an exemption from the inspection if it's multifamily and has 50% of its units occupied, including other exemptions. So at page 4, in line 26, multifamily property and has goes in, and in line 27 of the same page, 50% of its units occupied. So that's where that comes in. Amendment number 2. Oh, you know what? It might be helpful if I told you where we are in the virtual binder. That would be good.
Is it 167? Or?
Yes. Let's go right on in there. Okay, so we're now at page 5 of the bill, which is located on page 167 of the virtual binder. Thank you for your indulgence. Okay, so amendment number 2, it provides for a COVID hardship. Page 2, after line 9, we're going to insert a new subsection, and it talks about what the definition of a COVID hardship is. Then amendment number 3 happens on page 5 of the bill. It basically also provides another COVID hardship exemption for buildings. And there's another one on page 5 in line 5. And then we have further down that we need to change the maximum cumulative time period that a vacant dwelling or building may be exempted. And so we're going to say 2 instead of 3 there. We have agency comments from the DPI director. We have a PAFI statement that's in your virtual binder. And we have speakers here on behalf of the agency who would like to submit some comments to the committee.
Great. I just had one quick question, which is how often can this $1,000 fine be assessed?
I believe, I did not write this bill. I am towing the line here. I want to say that it's per violation, which would be 1 day is one violation? Yeah. That's what I thought. Okay.
And I'll note too, because I think the fine is low, but we're restricted to the $1,000. But I am working with Nick Charles on the state level to do something about allowing us to be able to have heftier fines. So the goal is that if that legislation does pass, we'll be able to have a higher dollar amount there. But this gives us a framework to start the registry.
Great. And for some reason, I thought we already had one, so I'm glad that you put this forth. Ms. Skinner?
Thank you, Ms. Ivy. So I just want to say on behalf of the administration, we've had an opportunity to review CB 80 2023. We do have some questions, and we're joined here with Associate Director Valerie Carey Carey with DPI, and Mr. Green, one of the inspectors. And I want to let them have a moment or an opportunity to weigh in on this. But just generally speaking, at this moment in time, we have no position because we do have some questions and concerns that we would just like to clear up. We understand the intent and the importance of this, but I just want to, be transparent and let everyone know that's just where we are right now.
Okay, Ms. Carey?
First, I want to thank you for the legislation. This is very helpful. We've been fighting with vacant properties for a while, and we've been a little restricted. So this mirrors roughly what they do in the district, and I've seen that be very helpful. I own property down there. So we only have a couple of concerns. My subject matter expert for vacant properties, I'm sorry for my voice, I apologize. My subject matter expert for vacant properties is the code enforcement officer who handles that, Donald Green. And I'll let him tell you what his concerns are. The biggest concern I saw was it would be helpful for us, like I love this legislation, thank you, but it would be helpful for us if we could if we could distinguish between personal owners and companies and LLCs and banks. Because what we found after the mortgage crisis was a lot of these properties fell into the hands of banks, and a $1,000 fine, to your point, is a walk in the park to them. So if we could make a difference in between what we are charging a personal owner versus what we're charging an LLC or an entity, that would be helpful. Also, I'll let Mr. Green tell you what his issues are. Thank you again.
Mr. Green?
Good morning. If I may add, as Ms. Carey just mentioned, one of our biggest challenges with enforcement of the vacant properties that we have within the county is the inability to hold mortgage companies, LLCs, and particular banks responsible for these properties, especially the ones that have become foreclosed on, even the ones where people have just walked away or even in tax sale. They tend to be an extreme blight on the county, and then we are, in most cases, tasked to clean and maintain them, and the county's not recouping any of that money. And that, of course, can be a burden on us as far as manpower and funding. So it appears that, well, I won't say it appears, but I will say that it would be a big help if that responsibility can be included in some kind of way within this legislation to place those particular entities responsible for the condition of these properties. Because we all know that these banks, LLC, they're going to sell these properties. They still hold on to these properties, and they can put them up for tax sale or what have you. The county's not getting anything off of this stuff, and it just continues to dwindle away at our funding and everything. To include, I'm big on the whole process of, I'm seeing the $1,000 fine. That's somewhat in our toolbox per se, but it would be a bigger hit and get a larger amount of attention if, again, these other entities are held responsible and anywhere up to $5,000 can be hit, you know, placed on them for each one of their properties that fall into that particular category. To include, once we issue particular citations, they, to get the most out of it, should go through the court system and not the administrative process. Through the court system, we can definitely get an order from a judge, at which point that order stays on that property for a while to include, make a determination of the type of abatement, which can stand from, you know, the property being cleaned and maintained, or the possibility of it being raised completely. And that's all within the code.
Okay, a couple of questions, but first, Mr. Olson?
Yeah, thank you. So, I guess, I mean, currently, we have a $1,000 cap on fines because of the state. And we actually are requesting legislation to increase that at the state level. So, I mean, if we can get that increased, that may help. Of course, if you go to court, that's a long, laborious process, and we've seen that in other instances with code enforcement and whatnot.
Correct.
Is there a way to have a dual track? Is that something that, I mean, if we can get the fine increased so that it, you know, helps, and it's per violation, so I don't.
So, yeah, I understand your concern, and you're absolutely correct. The problem we have, and it's not a problem, the issue is, in the administrative hearing process, it's very narrow. And an administrative adjudicator has limited responsibilities. But if we can get it into district court, as you know, the judge has
Right.
unlimited rights and responsibilities. And I understand your point, too. You're looking at a 90-day process versus a 9-month process. And yeah,
At least.
so,
Yeah.
and exactly, hopefully, and keep in mind, we have one court date a month designated for the enforcement division, and it's not even a whole day. It's from 8:30 to noon. So once a month, from 8:30 to noon, we have to get all of our cases, and that's what takes us 9 months, 10 months to get our cases before the judge. But if we can gut that out, it gives us so much more latitude on the back end as far as abatement and adjudication.
So, and I'm sorry, the legislation as it's written right now, does that, it would allow for a fine?
Yes,
And then it would go to court? It
yes.
could be taken to court after. Is that the process currently? Or in the current bill?
So currently, yes.
Okay.
That's what would happen.
And are you concerned about that, or no, you support that?
That's our process now. So I do believe, even though it's a longer process, that right now it should go through the civil fines and the district court process.
So you want to eliminate the ability to
Do the administrative
do the
hearing?
administrative? Wow. I mean, my concern there would be that, I mean, I assume you get some compliance in that first, through that first.
We
you
do
know?
for occupied properties because the
Right.
owner is still there.
I mean,
But for vacants, a lot of our vacants are people who don't even live in the area. They don't even live in the
Sure.
county. And some people don't even know they own these properties.
right.
Because they're the beneficiaries of
Right.
a deceased relative.
But my concern, my concern would be that if you don't go through that process, it's going to take longer. I mean, at least if you say we're going to have an administrative hearing, they're going to get notice of it, and that starts the clock ticking, and you may get some compliance. You may get 30% compliance. You
I
may get
understand.
25% compliance, but that's better than zero compliance.
And
In
that's a
my mind, I
valid
want to
point,
get
yeah.
compliance. However,
That's
the
sort of-
most effective way to do that is.
Trust me, so do we, because the more
I know you do.
compliance we get, the fewer properties we have to inspect.
Right, absolutely.
So,
absolutely.
no, I absolutely agree with you. I'm not opposed to both silos. I'm not.
Okay, okay.
I just are with vacant properties, not with the occupied properties.
Right.
But with vacant properties, we just seem to get more. It's a more complete process for us in the circuit, in the district court.
And
in
if
the
it
civil
goes
process.
there, fine. I mean, if it goes to the courts, and it will go to the courts if you don't get compliance.
Correct.
Within a certain amount of time. I don't know if we need to truncate that amount of time. Or,
No, it will be a 90-day process in the administrative hearing process. It would be
Yeah.
a 90-day process.
And then at the end of that 90 days, if there's not compliance,
Then we
then
take
you
it to
go to the
circuit
court.
court.
I think that's probably the right way to go about it.
No objection to that.
Okay.
That makes sense to me.
Yeah, I don't know.
I'm just happy about the legislation.
Yeah, great. I mean, I don't know if we need an amendment for that, or if the sponsor is okay with that, or.
With the two, I guess I'm not following because it would happen automatically the way it's written now. So what would the amendment be?
Well, I don't know if we need
Okay.
an amendment. I'm asking because
Okay.
it sounded like they wanted to circumvent the.
I did, but I understand.
Right,
since we've had
I'm leaning towards what you were bringing up, I think.
Right.
And also, I think part of the issue is going to be the fine amount. Because I think if we're able to increase that a fine amount,
Right.
We might get more compliance in the first phase without having to go to court.
Right, right. I mean, we know we're not going to get everybody complying. You know, That's
Exactly.
the way it is. But if we can get 20%, 30%, that's a benefit. That helps some, some neighborhoods.
Exactly.
Okay, so do we, I'm sorry, I mean, the
Well,
legislation.
Well, actually, we do have a speaker,
Do we, okay.
Ryan Washington from AOBA. Is he still
But I
here?
do want to make sure before we, Madam Chair, you're running the
Right,
meeting,
go
but I want to
ahead.
make sure that is there an amendment needed, or no, this is already the process that's laid out there?
They can figure that out while he's talking.
All right, I just want to make sure that's being looked at.
Ms. Zavakos, you're looking at that issue?
I'm not the drafter of this particular
Ms.
piece,
Is it
but it
Ms.
would be Ms. Canning, yes.
Ms. Canning, while Mr. Washington is speaking, will you be able to come up with whether or not an amendment is necessary for that? You don't have to answer yet. I just want you to be thinking about it.
It's
Mr.
okay, the way it is.
That would be what it was. That's all.
Mr. Washington.
Sure. As
You
everyone's
could introduce
deliberating.
yourself?
Yeah, thank you for the record. My name is Ryan Washington. I represent the Apartment Office Building Association. I'll keep my comments very brief. I just want to certainly highlight, thank the bill sponsor for being receptive to our amendments. I hope this is the first of many bills we'll be able to come to the table and support. I love coalition building. And just kind of harping back to the comments, we are supportive of the amendments because Montgomery County and Washington, D.C. already have very similar legislation. It makes sense to do property registry just to hold those unvacant and unmaintained properties accountable. And many of our members already, perform inspections, keep their properties up to code, and it's usually in best industry practices to always have a maintain vacant ready for sale for a potential prospective tenant. So that's why we wanted just to clarify language, just to ensure that building properties that are not actively renting and renovating their units and their buildings would be protected. And just to add on to the commercial office space sector, we do represent commercial property owners in the county. And as you all know, from just the significant impact with the COVID-19 pandemic, we've seen folks not return to office or adopting a more hybrid schedule. So it's been a decrease in people being in the office. So sometimes you'll have a lot of vacant properties and a lot of office spaces that are vacant, or property maybe the company left out their business and the lot is just vacant. So depending on market pressures, those properties can just sit there. So I wanted just to incorporate language just to offer those protections, as that may not be a result of the actual property owner maintaining it, but we can look further into that conversation. But I just wanted to go on the record just to go and appreciate the bill sponsor for listening to us and being receptive to our comments. So thank you, and I'll be available for questions.
Ms. Oriata, do you have any response?
No, just thank you for your amendments and thank you for your support. Hopefully, to your point, you can support a lot more of my bills. So I look forward to that.
Yes.
Thank you.
Thank you all.
I had one quick question before we continue. When someone, such as myself, reports on 311 a vacant property
Yes,
that looks terrible, what happens next? Because full disclosure, I reported on April 22nd, a house on Marblewood. I have it here open on my phone. It said expected resolution, and I don't know what that really means in this case, 6/23/23, and it's still open. So what is kind of how this is?
Our process?
Yeah.
Okay. So when you reported to 311, then we now go through a triage system. It gets sent to the vacant unit, and an inspector will go out and assess the property. It has to be, to your point, it's in violation of code. If it's in violation of code, then we have to find the owner. Sometimes that takes a minute. And then notify the owner of the violation and give them time to abate. I will say that I have 4 vacant property inspectors and roughly around 4,500 vacant properties in the county. Wow. So our SLA is that it will at least be touched, i.e. the inspector will go out in 7 working days. And we're meeting our SLA. But the process with vacants is a little more cumbersome because we have to make proper notification to the owner before we move forward with our abatement process. And sometimes nailing down who that is and how to find them takes a minute. And the Marblewood rings a bell with me. I think this is a problem property that we have cleaned before.
Probably. I drove past it yesterday, and it was still the same.
It rings a bell with me.
It might look worse. I mean, the neighbors tell me that the owner is around, doesn't live in it, has several properties. I think he just uses it to store things. It's cheaper for him than public storage or whatever, so.
Okay.
But I will definitely share it with you.
Thank
and
you,
if
if
it's
you would.
possible to update the 311
Well,
so
see,
that
we're in
can't do-
momentum now. So the update may be in our system in momentum. I'm not sure that 311 can see it. Now, they may be able to. I'm not sure. All I know is we're in momentum. I know our system. So I can go look and see where we are with that, and I can get back to you and let you know exactly when the inspector went out and what the inspector
Okay.
saw and where we are.
Well-
But this is what I will say to you, and I'll
Yes.
say to everyone, please. When you have a crime at your house, you call the police. You're not talking to the police department. You're talking to Public Safety Communications,
right?
right? So Public Safety Communications sends out an officer. Officer comes, he takes your complaint, he gives you a card and says, "Ma'am, the detective will be with you, and here's your number." When you go to find out what's happening with your case, you don't call 911 again.
Right.
You call the police department. So what I would say is, if you want to know, that's one reason why we would really like you to get in touch with us, because 311 may not know.
Sure.
What we're
I
doing.
understand what you're saying. I guess somewhere out there, whoever runs these things, and it's not the county council, we are told to report things to 311.
That's correct.
We are told that that's where we can track things. And we're also told that that's where the public can report and track. But I know that I might be able to reach you and say, give me an update. The average citizen, and this might not be your problem to solve, but it is the county's problem to solve, needs to be able to follow those complaints and feel like they've been heard.
That's
'Cause
correct.
I've checked this one a number of times, like either drive by or look at my phone at the app. I'm like, nothing, you know.
Right.
I'm not expecting it to be torn down when I drive by, but I expect to get some
Yeah.
kind of
Also,
information.
what I will say too, also understand that our inspector may have done everything they needed to do. Gone out, inspected it, put in paperwork to have it cleaned, but we've got 4 contractors and a ton of cleans.
Yeah.
So it may just be sitting on that list waiting for the contractor to come through. So we go back to, if you contact us, we can tell you where we are in that process.
Okay.
And it may be frustrating waiting for a contractor to get there, but it may already have been given to the contractor to get by and clean. I can let you know where we are in that
Okay.
process.
Thank you, and I'm not trying to hold up this whole hearing
No,
for the
that's
sake
quite
of
all right.
one case, but I
Any-
did think that was an example
Anytime
of,
I get to explain, it's fine. It's all right.
thanks so much. Are there amendments that need to be moved?
Pardon me, there's an additional amendment.
There's an additional amendment, I knew it.
I know it. I'm sorry. Bearer of bad news. Page 5, line 3, strike Office of Zoning and Administrative Hearings and supplement or substitute or zoning hearing examiner.
Yes.
Okay, Ms. Oriata, would you like to make a motion for that amendment?
Yes, make a motion for
there
that
more?
amendment.
I'm so sorry. Usually, yeah. Sorry, before we go further, Chair Denoga has apparently been trying to get my attention.
I had one concern about the bill, and maybe this is taken care of, and I just don't see it. We have a lot of complaints about vacant properties being taken over by squatters, and I don't see that there's a reference to that such that it might be implied that a property is vacant, but if a property is being occupied by squatters, because this is something we've had lots of complaints about. I remember Senator Benson bringing this up, Ms. Legay. I remember at the, I think it was the Realtors Breakfast or something last year, that, you know, it's hard to deal with in general, but if you're setting a vacant property law with a registry, et cetera, what do you do if there are squatters? I think it should be excluded from the definition of,
So what I'll say is, the illegal occupation of a residential property is a police matter. It's criminal. So it's, what we work with the police department, but we don't have,
that's not my issue.
what's your issue?
My issue is it vacant in terms of the definition? Because it should still be considered vacant.
Yes,
And
it
be
is.
on the registry.
For us, it is also considered vacant, and that's what we were doing with the police department to get people out of them.
Right, but I don't see in the definition anywhere where,
I do.
yeah, thank you.
Page 5, page 3, line 10,
Hold on. Page 3, line 10.
line 9. Dwelling or building is only vacant dwelling or building if the director determines that there is no resident or owner for which an intent to return and occupy the dwelling or building can be shown. I think that was the intent. I'm not sure if it gets.
I think that's vague. No, I think you're right. I think that's a good point. I mean,
In 8, do you want to say?
she wants to add the word legally to the occupying. See, I raised a question, she hit it home.
Page
Good
3.
teamwork.
Got it.
Thank you, Ms. Ivy, that's all I had.
Thank you very much, Chair Denoga. That was a good amendment. Do we need to move that amendment?
Make a motion to move with favorably both amendments.
Okay, second. Please call the roll.
Chair Ivy,
Aye.
Vice Chair Olson,
Aye.
Councilmember Blagay,
Aye.
Councilmember Denoga,
Aye.
Councilmember Oriata.
Aye.
Motion carries 5-0.
On the amendments.
Ms. Carey, Director Carey.
Yes, ma'am.
Ms.
Go right
Ivy, I
ahead.
just wanted to give Ms. Carey an opportunity. I believe when she was speaking back and forth with Councilmember Olson, there was a question about a possible amendment. So I just wanted to see if just circle back to that.
Right.
Oh, go right ahead.
It's fine.
Sorry.
It just, you know.
No. So one of the problems we have when we are trying to litigate some of these cases is we have to have a person. Bank of America will say, Bank of America owns it. But for us to take it to court, we have to have a person to charge. We can't charge the company. If you're going to write a citation, we have to have a person. So I guess my ask would be is if there's some way we could, in this legislation, in the registry process, make it necessary that as we register these properties, there has to be a person, a representative, that is held accountable for the property. Because especially with these mortgage companies, LLCs, they just hide behind their corporation, and it makes it very difficult for us to bring somebody to court.
Mr. Denoga, do you have an answer for that one as our attorney?
Actually, I was playing attorney on something for Ms. Blagay, so I did not hear that. I'm working on other legal matters. What's the question?
They need a person to sue.
Resident agent as,
Resident agent.
Well,
that was more.
sometimes we can find the resident agent, but all of these companies, a small LLC won't have one. And
Okay,
they-
they're
They're
legally-
required to have a resident agent.
yes, I understand.
But then
Well, then
can't
the
you
court will
serve-
find judgment.
But can't you serve the
Okay, trust me.
attorney general?
we're
I
in
thought there was a
court.
fallback provision for if
We're
there's
in
no
court.
resident.
So, our problem with like companies like Bank of America, for instance, when we identify them as the owners because they are the mortgage holder, we have problems identifying someone in that corporation that we can take to court. We can't cite the company.
But they're required to have a resident agent
They
as a
are,
corporation.
I agree.
I don't think she's, I think we're in agreement there. I think
Yes.
she's saying the requirement is there. The entity knows that, the business entity, and Ms. Carey knows that, but they're not still able to locate
Thank you.
a representative.
That's what-
And quite frankly, I don't even know if that's
Anything that we can-
do with
anything we can do
CB80.
here.
But that's why I wanted to clarify if there
Right.
was regarding CB80 or not, or maybe this is something we can talk offline
We can
about
talk
to
about
help
it.
you guys with that issue.
So actually, if you go to court and they don't show up, then you can ask for judgment by the court. And that gives you, then, the court has the ability to find judgment for them failing to show up. Because if you sue the resident agent and you give notice to the resident agent and they don't show up, then they're in contempt of court.
I understand that, ma'am.
So then that way, the judgment can be found. I mean, in other jurisdictions, then that would allow at least there is a vehicle where you can move forward with the property, even if there is, and I'll go back because I know when they've done this in DC, where then the property can become the property of the city, and then the city can sell it for a tax sale.
Ma'am, I understand that.
So then-
I
Our
think-
problem is when we go to find that person in the company says, well, they no longer work here. Okay, well, who is your resident agent?
Well, that's not your problem. Like, I mean, you go to court, and then that's all you need to say. We tried to serve the resident agent. The resident agent didn't show up, and that's all you need to tell the judge. And then you have your attorney say, we are asking the
that's my
court to find judgment.
Okay.
Ms. Blagay, and I know you're doing your job, and what you're doing is correct. But I'm hearing, Ms. Skinner,
Uh-oh, first name.
is that the Office of Law is not doing its job.
I am not going to say that.
I'm serious. I'm not
No,
being funny.
yeah, no.
If they don't, I mean, it's not on her to know how to get this done, but the fact that the person has moved on,
Right.
well, then they're in violation of the state corporate registry.
I agree with you.
Okay, so they're operating in violation of the law as a corporate. So in addition to having
Yep.
the vacant property, they also have a corporate legal status problem, which I would think, if you're Bank of America, you'd want to fix.
Right. No, I agree with that. My recommendation would be, and thank you for this opportunity to allow Associate Carey to articulate what her issue is. I don't think for the purposes of where we are with CB80, we need to make any amendments based on that. I think that's something separate and apart in a discussion with Office of Law and DPI offline.
Yes, offline, but that's actually a bigger, it's like the Seinfeld episode where you take the reservation, but you don't hold the reservation.
But we're not going to do Seinfeld right now, okay?
We do it every day, don't we?
We just did a bill about nothing, so. Oh, you don't want me to say that. Oh, I apologize.
I think
The
we're
funny
up to
thing is,
a
everyone knows the bill I'm talking about, too.
I know. I'll make a motion to now move favorably with the bill as amended.
Please call the roll.
Chair Ivy,
Aye.
Vice Chair Olson,
Aye.
Councilmember Blagay,
Aye.
Councilmember Denoga?
Absolutely aye.
Councilmember Oriata? Aye. Motion carries 5-0.